as it makes its finding and ruling in respect to the prayer sought for the arrest warrant, let those responsible for executing that warrant also be held responsible in the event that the orders of this court are not complied with. Unless the officers are held in contempt for failing to effect those orders, we shall be treated to these suckers each and every day. The court has done its work, but then there are other arms of government that are failing to execute the orders of this court. That is all you are.
Now, this is a matter which was brought to court for plea taking on the 22nd day of December 2023. The second accused person and his counsels have always attended court without failure. I equally empathize with the second accused person and his counsel for having to be drawn into the entire quagmire that they find themselves into. I'll bet that there was a hearing date set for the hearing of this matter, and I'll bet with the court aligning herself with all the legal provisions of Article 159 of the Constitution, the court availed itself to take plea where his counsels, that is the first accused counsels, averred that their client was. Unknown to this court then, it was at the Nairobi hospital. Again, the court was not allowed to take judicial notice if indeed the accused was in the Nairobi hospital. This week again, on the application dated the 19th day of March 2024, the ODPP made an application that the accused be brought to this court today for plea taking. Counsel for accused is in court today and avers that they will be in court tomorrow. It is perturbing and quite worrying that accused and the said counsels can decide when and where he would wish to take his plea. Counsel Ahasa himself being in court today confirms that they were aware that plea is for today. The court order is duly signed. Counsel for first accused is in court because of this application, but ironically, his client is not. This is quite a coincidence. This only confirms what Counsel Mburu has averred, and I concur that the theatrics are now being taken too far. I have equally seen an affidavit of service which confirms that the first accused person was duly served for plea taking today, and counsels received the same at 16:12 hours on the 20th day of March 2024. The admission is glaring, yet A1 is not before court today. This court has been accommodative to this extent. Prosecution and counsel watching brief have equally done everything legally possible. Sadly, the counsels for first accused have severely been putting an application after another to avail first accused, but they do not do so. I equally agree that the police have either been reluctant or otherwise as to why accused has never been arrested. A1 has even been granted anticipatory bail before my seniors at the High Court, and yet he's not before the court. This is a classic case of defiance. What example could this be all about? Having said the above, having had the counsels for A2 and the prosecution and counsels watching brief, this court fully stamps its authority in finality that a warrant of arrest hearing for the 10th time to the first accused person, failure of which forthwith, further orders will be issued accordingly. The law enforcement is herein and are duly legally advised as per a functional and legally binding Constitution 2010. These are the orders of this court. Hearing date is as what we had agreed. Is it the 9th?
Yes, the hearing date is the 9th.
9th of? That is it. You're welcome. Say-
Okay.
Yes. Who this wants me? Come on. No.
Yes,
Warrants have to be lifted first before he takes it.
yes.
You understand? So this is not the matter was not scheduled for mention right now. That's what I'm saying. So that's a procedural. Sawa, mimi niko kotini.
Why are you teaching an expert? No.
Solo wetu-
More than he teaches.
Nonetheless, land reference number 18485, IR number 640111, measuring approximate area of 7.39 hectares, situated along Lower Kabete Road, valued at 10 shillings, 1,350,000,000. The property of Ashok Rupshisha and Iten Kumar Amritlal Raja. Davis Nadan Chelogoi, true or not true?
Not true.
Not true. Count number 2. The charge is possible detainer, control section 81, as read with section 36 of the Penal Code, and particulars are on unknown dates between 9th December 2020 and 12th December 2023, along Lower Kabete Road within Nairobi City County in the Republic of Kenya, being in possession of land, reference number 18485, Inland Register, that's IR number 64011/1, of approximate area of 7.39 hectares, situated along Lower Kabete Road, belonging to Ashok Rupshisha and Iten Kumar Amritlal Raja, without color of right, held possession of the said land in a manner likely to cause a breach of peace or reasonably apprehension of breach of peace against Ashok Rupshisha and Iten Kumar Amritlal Raja, who are entitled by the law to possession of the said land. Davis Nadan Chelogoi, true or not true?
Not true.
Count number 3. The charge is forgery, contrary to section 345, and particulars are on or before the 9th December 2020, at an unknown time and place within the Republic of Kenya, jointly with intent to defraud Ashok Rupshisha and Iten Kumar Amritlal Raja of a parcel of land known as land reference number 18485, Inland Register IR number 64011/1, approximate area of 7.39 hectares, situated along Lower Kabete Road, valued at Kenya shillings 1,350,000,000. Forged a certain document, namely a letter of allotment, reference number 75707, dated 31st January 1995, for land reference number 18485, Inland Register IR number 64011/1, purporting to be a genuine valid letter of allotment issued by the Commissioner of Lands. Davis Nadan Chelogoi, true or not true?
Not true.
Count number 3. The charge is forgery, contrary to section 345, as read section 249, and particulars are on or before the 16th day of January 2023, at an unknown time and place within the Republic of Kenya, jointly with others not before court, with intent to defraud Ashok Rupshisha and Iten Kumar Amritlal Raja of a parcel of land known as land reference number 18485, Inland Register IR number 64011/1, of approximate area of 7.39 hectares, situated along Lower Kabete Road, valued at Kenya shillings 1,350,000,000. Forged the signature and stamp impression of Pauline Acheng Pesa, a land registrar with the State Department of Lands and Physical Planning, on certificate of title LR number 18485, IR number 232908, purporting to be a genuine and valid signature and stamp impression of Pauline Acheng Pesa. Davis Nadan Chelogoi, true or not true?
Not true.
Count number 5. Uttering a forged document, contrary to section 353, as read with section 349, and particulars of the charge are: on the 11th day of October 2023, at the Directorate of Criminal Investigations Headquarters, Masingira House, along Kiambu Road, within Kiambu County, in the Republic of Kenya, knowingly and fraudulently, uttered a forged document, namely letter of allotment, reference number 75707/7, dated 31st January 1995, and a certificate of title LR number 18485, IR number 232908, bearing a forged signature and stamp impression of Pauline Acheng Pesa, to service number 80936, Detective Corporal Nicholas Ozuri, purporting them to be genuine and valid letter of allotment issued by the Commission of Lands and such issued by Pauline Acheng Pesa, a land registrar with the State Department of Lands and Physical Planning respectively. Therefore, is Nathan Chelogoi, true or not true? Count number 6, obtaining or procuring registration of land by false pretenses, contrary to section 320 of the Penal Code, and particular, sir, on the first days between 9th day of December 2020 and 4th June 2021 at the State Department of Lands and Physical Planning within Nairobi City County in the Republic of Kenya, jointly and unlawfully with intent to defraud, procure registration of a parcel of land known as Land Reference Number 18485, Inland Register, that's IR number 64011/1, of approximate area of 7.39 hectares situated along Lower Kabete Road, valued at Kenya shillings 1,350,000,000, by falsely pretending that David Nathan Chelogoi is the lawful and the registered owner of the said land, reference number 18485, Inland Register IR number 64011/1. David Nathan Chelogoi, true or not true?
No true.
Those are the charges.
When the order was very clear that plea taking won't. However, if there are compelling reasons And Your Honor, I also refer to the bail and bond policy guidelines. And in the same guidelines, court should also take judicial notice of the conduct by the accused person in granting bail.
Why are we having these proceedings a few minutes to 1 p.m. today? It is because on this 21st of March 2024, we were before you at night. The first accused did not show up in court. The counsel who was representing him confessed and confirmed that the order that unequivocally talked about today's session or plea taking was served upon them. So we can say at the very beginning, the reason as to why we're here this afternoon is because you issued a My submission stems from there. If you look at a party who was forced to attend before you, courtesy of a warrant which you have and a ruling, it was very candid this morning, who is before you, what are we looking at? We're looking at possible scenarios that the court has to consider if it's to be admitted on bond terms. The very first thing that we agree about is that under the Constitution is entitled to the same. But who are we looking at? We are looking at an accused party who on the 22nd of December 2023 failed to attend this court. We are looking at an accused party who on the 15th February 2024 failed to honor your court summons. We are looking at a party who on the 27th of February again, that's the third time, 2024, failed to honor your court summons. We are looking at a party on the 12th of March this month, 2024, for the fourth time, a party who has not honored your summons. Now we are looking at a party who, Your Honor, on the 14th, this court now had to leave this particular premises just to go and pay him a visit. A circumstance that did not allow us to have an access to that particular hospital bed. You know, now when you look at these particular scenarios, what are we looking at? We are looking at the aspect of a party proving to be a flight risk. In other words, if plea taking has been this difficult for him to honor your summons, just to come and take his plea on, how would you admit such a party to bond or bail terms as such? That is the big question this morning, Your Honor. Your Honor, secondly, away from the aspect of flight risks, the second thing to consider if you are to grant him on either bond or bail terms is the risk that he will posit upon the witnesses. You look at the charge sheet, the first two witnesses are the people who I am watching brief for. That's Mr. Ashok Kumar and Etienne Kumar Raja. Your Honor, the first accused party has a group of middle-aged men of about 21.
Let's not get there.
Yes, Your Honor, it's about...
That will be during the hearing.
Yes, Your Honor.
So let's not get there. Let's strictly adhere
Yes.
to bond and bail.
Very well, Your Honor. So what I'm saying is, the first accused party proves to be a risk and a danger to the witnesses who are supposed to testify in this court when we get to the point of admitting this matter to hearing. Your Honor, again, the first accused party who is before you, who seeks your clemency or your indulgence to admit him on any strict or bond or bail terms, has not been subservient to your court. So the big question is, why would your court be easy on him when on the 22nd December he has crossed the Kenyan borders to Uganda? Your Honor, for us, as we continue watching brief for the victims, we are looking at your court with clean, open eyes. We know how much you are committed to having this matter proceed. We know how the first accused has been unfair to the second accused in terms of court attendances. You know, he may be a senior citizen, but he's a member of the public when he's in this court, just like any other person. Let us deal with him just like we would have dealt with our Jiku or a Robert somewhere. So, Your Honor, on that note, do not admit him to any bond or bail terms. I think he should serve, he should be in detention until we get to the point of hearing. That is our kind request. So that, Your Honor, any parties who are facing such counts under your charge sheet, this will be a lesson. This is something that the entire country is following. There's a lesson to draw. And I think potential Kenyans, Your Honor, who may end up finding themselves where he's finding himself in, have to have some lessons to draw from this court. Your Honor, let us deal with this matter in the strict sense that it deserves most. That's all.
Circumstances as the first order, yes, order number 1, it's here by order, yes. In whatever circumstances as to be advised by his doctor, and if still admitted in the hospital, the third respondent, then his doctors, to present him at Milimani Court for plea on or before 22nd March. The 22nd March is tomorrow. Number 5 is...
Number 3.
Number 3, the matter we mentioned on 21st, which is, it was 22nd, then it's changed 21st.
Yes, before the signature.
Yes,
And
before
it
the...
has not been countersigned again, it was 21st. Because what was said in order 1, on or before the 22nd,
Yes.
and the votes will actually concur, because you know I was for the JSC,
Yes,
and that is why we had to...
of knowledge, I think that is the...
Yeah,
because-
but I will not, it's not you I'll put
Yes,
to
yes.
strict proof, but
Yes.
your law firm actually received this on the 20th at 16:12 hours.
Yes,
The first page
and your-
on the face of the application.
Yes, Your Honor, at the point, just to submit, at the point I knew that we would present ourselves for plea. In fact, I didn't know about 21st, I knew about 22nd. For some reason, that is what went to my mind. And I was just learning of the 21st today, I must confess. So, Your Honor, inadvertence of counsel would be on our side in terms of the date. Our reading was that we present ourselves for plea tomorrow. I prepared him for tomorrow. And so today, when Advocate Asa came to court, he had called me, told him we must get Mr. Chelogoi to appear in court today. That's an expression of good faith on our part. We did to stop what I was doing, to run and to look for him. Your Honor, in terms of all that my learned friend Mr. Ashok has said, Bashir, yes.
I don't know why you people
I don't know why, I think it's an easier name.
Your client is Ashok.
Yes, Your Honor, Mr. Bashir, it is clear that no affidavit has been sworn by the prosecution on the possibility that this accused person is a flight risk. At the time the first plea was taken in last year, Mr. Chelogoi was already in Uganda days before the plea was taken. He was not away. The next time, Your Honor, this matter came up, we've exhibited medical records that have been verified by the investigator. We are not, I do not think that a man of his age would remain in monkey business. Other than health, his health reason is why he did not attend. I advised and would have taken plea much earlier had he been in a position to attend. Your Honor, if you even look at this, I'm a layman, but the kind of blood pressures that you see here, over 90, are crazy. You wouldn't even be in a position to walk. Your Honor, the provisions of Section 123, Article 49, and the Constitution now makes bail an absolute right. Absolute, of course, except that the court may, under the guidelines, temper that right, but not to take it away. So the right should and ought not to be taken away through punitive terms. That is what the various decisions of cases of value before the court find. In as much as my learned friend submits Mr. Bashir, that the court should deny bail, I don't think it would serve the complainant in any measure if my client is detained. It does not serve their interest. Their interest is to have the case heard expedited and heard so that they get their justice, if at all that justice exists. At this point, Your Honor, justice is a two-edged sword. It lies both for the first accused person and for the complainant. It might be as well that after the court does the hearing, may find that the correction of the property is the accused person. So we pray, Your Honor, that this court be tempered and be guided by the President that it has set in settling the question of bail for the second accused. That is our prayer, because the object of bail, Your Honor, and that is set out in several authorities that we have argued, is to ensure his attendance to court. If he fails to attend court at a date that the court will fix, then the court would cancel the bail and put him in. But we are not yet there, Your Honor. So let us not preempt this old man who looks very harmless. I can look at his face, that he will disobey the court. He's a serious man. He's a senior man, but he's also sick. That's all.
A ruling that the ruling will be on the 25th of March 2024 in the morning. I really don't want to get into what he should be. Just a minute, Bishar, just a minute. I don't want to start getting into the nitty-gritties of all these things. I will give a ruling on the 25th of March 2024. Just a minute. And I know now the next question will be, where will you be put? Earlier on, there is a warrant of arrest. I have not mentioned anything about that. There was a warrant of arrest. I have not mentioned. I'll say I'll give for bond and bail 25th of March. Should I also now execute where he should be taken? Counsel, I don't deny, and I say this with all humility. I don't want to get into that, and if I say anything more than that, then I'll be getting into the nitty-gritties of this matter. Where we are at, it's also not going. It's not also very easy for me as a court, but I will definitely give a ruling on the 25th of March about the bond and bail. As to where he is going to be taken, I will not want to delve with that. And why I don't want to mention that, because this case already is building a history. So I will give a ruling on the 25th of March 2024. At 9. Yes. Accused 2, we have a hearing date, 9th of April. So we are done with him. He has a hearing date, you have the documents. Yes, for this one, I give a ruling on the 25th of March and 2024, and counsel, a senior counsel agenda, just as you had directed and also made your submission, that I also, in favor of your client, that I should also see that there's that's accused 1. Accused 1. Yours is accused 2. Yeah, and what I gave as the bond terms for accused 2 should also be considered. Yes, and that is why, because you are in this matter, I don't want to delve in that, but I will equally consider that. And even when he took plea, I retreated and wrote a ruling. So my ruling will be pronounced on 25th of March 2024. Usually, okay, if you want me to say this, usually when somebody takes plea, the court does not further direct what happens or where the accused person should be taken. The court directs itself to what is before the court, which is an application for bond and bail. It is not an application where the accused, now he's an accused, and they are, because he's now before the court and he has taken plea, but the court does not take, does not further direct where an accused person who has taken bail, you know, counsel, you know what happens. Let me not get into that because that is not an application before the court.
We normally apply where in this situation, we normally apply this way.
I was avoiding that because you've just come from Nairobi Hospital and you know what happened. I have seen the application that we had and I can see now Nairobi Hospital was involved. It would only be fair enough that Nairobi Hospital would have now been on the dock. And that is why I don't want to make an application on something which is not before the court. Yeah.
I think that is what we follow after this. That's clear, Your Honor. I think that's your point is clear. After the court session, the invitation to court session is today. The warrant of arrest of the issue will not stand here. That is what the court has still the result. So that is the
Maybe maybe it's an issue that the court would have dealt with.
Let me just leave it at that. We will have too much back and forth. Last week when you asked us to stop you there, and that was the position. So allow me to say this, that the ruling will be delivered on the 25th of March, 2024 at 9 on the bond and bail for the
Yes, sir.
Watu wamalizie.